Good morning, Madam Ida. Allow me to introduce our group members. Lim Li Xing, Oh Ke-ying, Ruth, Maureen, Lo Xing-ying, and Sherry Yong Jing Ru. We are Group A from Tutorial Group 2. Before we dive into the topic, I would like to briefly summarize the case situation. Amazing Toy Company ATC in Hong Kong contracted to sell 2,500 solar-powered talking Barbie toys to Suga Toy World STW in Kuala Lumpur for 10,000 FOB Hong Kong. Bersatu Bank in Kuala Lumpur issued a letter of credit in favor of ATC, with Hong Kong Bank acting as the advising and negotiating bank. The letter of credit requires specific documents including a bill of exchange, commercial invoice, clean bills of lading, certificate of origin and packing list. On April 4, 2023, the shipping documents and bill of exchange were presented to Hong Kong Bank, whereas the goods were loaded on March 19, 2023. However, Hong Kong Bank refused to pay due to non-conformity of the presented documents. The bill of lading was marked French collect instead of French prepaid. The certificate of origin was signed by an officer of Hong Kong inspector without proper authority from Hong Kong Custom. Hong Kong Bank then contacted Bersatu Bank for a waiver, but it was refused due to STW's senior executive absconding with the firm's liquid assets. STW has been placed in liquidation. The first question is to discuss ATC rights, if any, in relation to Hong Kong Bank and Bersatu Bank. The issue in hand is whether Amazing Toy Company ATC has the rights against Hong Kong Bank and Bersatu Bank regarding the non-payment under the letter of credit. Article 2 states that the applicant means the party to whom credit is granted at its demand. This regularly refers to the buyers in letter of credit, whereas the bank that provides letter of credit at the applicant's request or under its own name is usually called the issuing bank. This is ordinarily the buyer's bank. The beneficiary is the person who supports the letter of credit. Frequently, the vendor is implied here. An advising bank is the bank that offers services at the request of the issuing bank. Usually, this is the seller's bank or a nearby bank that is located in the same country as the seller. All of these definitions explained above are under Article 2 UCP 600. It was shown by a deal Amazing Toy Company ATC in Hong Kong entered into a contract with Suga Toy World STW in Kuala Lumpur to sell 2,500 solar-powered talking Barbie dolls. As STW was a new client, ATC sought payment through a letter of credit from STW. On March 14, the Hong Kong Bank notified ATC that Bersatu Bank in Kuala Lumpur had granted ATC a letter of credit. In this circumstance, ATC served as the seller, which is beneficiary, and STW as the buyer, which is applicant. Furthermore, Bersatu Bank is an issuing bank, whereas Hong Kong Bank is an advisory bank.
To discuss the issue whether ATC complies with the terms of the letter of credit. Under Article 4 UCP 600, a letter of credit is a procedure entirely separate from the contract against its validity may be created, and the relevant bank has no obligation to know is not compelled by any particular kind of contract. Besides, under Article 5 UCP 600 stipulate that concerned bank only deal with the document instead of any prospective related goods, service or performance. In this case, Hong Kong Bank's justification for refusing to pay was that the supplied paper did not match the requirement outlined in the letter of credit. The accompanying paperwork suggests a problem since the bill of lading that ATC has supplied is marked freight collect rather than freight prepaid, which is exactly the letter of credit stipulated to be executed. Therefore, under Article 14A UCP 600 outline the criteria for the bank's review. It stipulates that the relevant bank must assess the seller's submitted document to ensure that the seller seems to comply with the requirement of the letter of credit before deciding whether to accept or reject it. Besides, according to Article 2 UCP 600, a compliant presentation is one that details adherence to credit laws and regulation. In this case, the Hong Kong Bank announced on 11 April 2023 that payment was not accepted because the given document did not meet the requirement of the letter of credit. The issue with the document first seems to be that the bill of lading issued by ATC indicated freight collect rather than freight prepaid, as the letter of credit specifically required. Under representative case include Moralic London Limited versus E.D. Mann in 1954. The letter of credit provided a bill of lading for 5,000 bags. The bank decisions to withhold a bill of lading mentioning 4,997 bags was deemed legal by the court. A bank has the right to reject papers that do not exactly comply with the condition of a letter of credit. Another case is the J.H. Rayner Company Limited versus Hambros Bank Limited. In 1943, the COA held that the bank was entitled to do so since the wording in the bill of lading was clearly not the same as those required by the letter of credit. It proved the legal doctrine that a bank has the authority to refuse documents that do not precisely adhere to a letter of credit's requirement. Additionally, when viewed in the context of the letter of credit, according to Article 14D UCP 600, state that while the information in one document need not be identical to the information in another specific document or credit, it also cannot be in disagreement with it, in accordance with rules and international standard banking policy. Although a Hong Kong Inspectorate official signed the beneficiary certificate of origin, there was apparently insufficient proof that Customs and Excise has given the organization permission in this particular circumstance. In referring to the case law of the Equitable Trust Company of New York versus Donsor Partners Limited in 1927, ATC did not comply with the terms stipulated in the letter of credit. Therefore, ATC has no right against Hong Kong Bank's refusal for the non-payment of letter of credit. The next question to be addressed is whether the ATC was presented within the time frame specified in the letter of credit. Under Article 6D 1 UCP 600 asserts that the time frame of presentation must be specified in the credit. It is hereby considered that the deadline for payment state for the purpose of encashment or negotiation is the maturity date presented. Therefore, the regulation applicable in this present scenario specified that the presentation must be performed within 15 days of shipment as well as within the letter of credit validity period. The beneficiary or its representative is required to provide one or more original transport document within 21 calendar days of the shipment date mentioned in this regulation, as including 19, 20, 21, 22, 23, 24, or 25, but in no case later than the deadline for the credit under Article 14C of UCP 600. A letter of credit is only opened on behalf of the seller when he knows that it is in his favor. In this particular discussion, ATC received from Hong Kong Bank that Bersatu Bank in Kuala Lumpur has recently issued a letter of credit for ATC on 14 March.
On Wednesday, March 19, 2023, the goods has been loaded and an official bill of lading was issued. However, the shipping document and the bill of lading were only handed to the Hong Kong Bank on April 4, 2023. Since the letter of credit instructs the statement should be made within 15 days of shipment and during the validity of the letter of credit, it showed that the presentation made on 4 April was out of date, as illustrated by the Hong Kong Bank refusal to pay. In the Republic National Bank of New York and Bank Commercial Port Europe the North 1998 case, dealt with the issue of production made outside the validity period of a letter of credit. The court held that the presentation of documents beyond the validity period of a letter of credit constitute a non-conforming presentation which justified the bank refusal to pay. According to Article 34 UCP 600, the bank is not responsible or liable for the document validity. The bank does not go beyond the document further to verify whether the details within it are accurate. Therefore, ATC has no rights against Hong Kong Bank refusal for the non-payment of letter of credit. Coming to this slide, whether the causes of STW bankruptcy result in the Bersatu Bank taking the risk. If there is an inconsistency in the document, it may refuse to honor it in accordance with the Article 16A UCP 600. ATC has the right to request a waiver of discrepancy from Bersatu Bank. If the bank decides not to accept it, it must specifically state this in a note to the advising bank under the Article 16C UCP 600. Article 16C1 and 16C2 UCP 600 declare that the notice must include two things which: first, a description of the bank refusal to consent or to bargain the payment, and two, a breakdown of each reason why the bank is refusing to approve or discuss. When the Hong Kong Bank approached Bersatu Bank to waive the discrepancy, Bersatu Bank denied. This is because senior management within STW absconded with almost all of the company's liquid assets, and the company has been liquidated. The first case law to take into consideration is Fortis Bank and Stermore UK Limited, an Indian overseas bank of the year 2011. Therefore, ATC has no rights against Bersatu Bank for the refusal to waive the discrepancy. The bank can refuse to pay if the document is not complementary to the letter of credit, since the bank only verified the inspection document and not the sales of goods by virtue of Article 14A UCP 600. In light of this, it is conceivable that the ITC has no legal rights against Bersatu Bank or Hong Kong Bank. Question B. If ATC cannot compel the banks to make payment, does it have any rights against anyone else related to this transaction? Discuss. The issue arises here is whether Amazing Toy Company ATC have the right against Suka Toy World STW that are related to the transaction, considering that ATC cannot compel that banks to make payment. ATC's ability to get payment directly from Suka Toy World may be constrained due to senior executive fleeing with case asset and the company being in liquidation. Hong Kong Bank refused payment as document presented failed to meet the specified requirement of the letter of credit. According to Article 14, the standard for examination of document, what constitutes a compliant presentation and specify the supporting document, must adhere to the letter of credit terms and conditions. Referring to case law of Malayan Banking Berhad and Punjab National Bank 2022, High Court held that principle of stringent conformity was applicable under the letter of credit system. Therefore, Amazing Toy Company insisted on receiving payment through a letter of credit as STW was a new customer. The bank has its obligation to advise ATC to withhold payment if STW's documents do not meet the requirements.
Whether Amazing Toy Company ATC have the right against Hong Kong customs that are involved in this transaction, considering that ATC cannot compel the bank to make payments. ATC lack of ability to enforce payment from Bersatu Bank, which may raise potential against Hong Kong Custom. In this case, Hong Kong Custom officials cite the certificate of origin provided by ATC without authorization. Due to lack of permission from Hong Kong Custom, officials may be held liable for distributing false documents as if it is found to be ineligible to provide the certificate. According to UCP 600 Article 17b, as each document with issue, original signature, mark, stamp, or label as original. Banks are responsible for accuracy or validity of documents as including certificates of origins. Therefore, ATC should verify authorities of Hong Kong Custom authorized agents. Whether Amazing Toy Company ATC have the right against shipping carriers that are involved in this transaction, considering that ATC cannot compel the bank to make payments. Carriers' bill of lading BOL serve as contract of transport. In this case, error on bill of lading, which is BOL, marked as freight collect instead of freight prepaid as specified by letter of credit. BOL should fulfill terms under Article 20 UCP 600 required by letter of credit. In result of breaching Article 20 UCP 600, the BOL does not state good delivery on board a designated vessel with prepaid status. Therefore, ATC may be entitled to hold the shipping carriers liable. Relevant case law of Bank of Tokyo versus Mitsubishi Trust and Banking Corp. 1986, 1 Lloyd Representative 94 support holding shipping carriers liable for mistake and carelessness. Shipping carriers may be liable for inaccuracies caused by their mistake and carelessness. ATC may have a claim against shipping carriers under Article 20 UCP 600 due to disparities in the bill of lading. In conclusion, if Amazing Toy Company ATC unable to enforce the banks to fulfill the payment obligation stated in letter of credit, its ability to recover payments from Suka Toy Works may be limited due to the staff absconding with the company asset and the subsequent liquidations. On the other hand, ATC may have rights and remedies against Hong Kong Custom and the shipping carriers. That's all from our group. Thank you.